What's up, everybody? Welcome back into the episode of the Lawyer You Know podcast. And I'm really excited for this podcast because somebody said throughout the entire trial that Emily Baker doesn't see it like this. Emily Baker said this. Emily Baker said that. How do you guys see this case so differently? So we figured we'd have to have Emily on and talk about it. And for those of you that don't know Emily, she was a longtime prosecutor in LA, and she is the stream queen now. Gavel to gavel, these big cases. Everybody goes there, watches the entire case through, hears her commentary throughout, basically like a color commentator for people that like sports, right? She brings the energy, she brings the fun. She's funny, witty, but very smart and a very good lawyer. So when she sees something different than me, I like to talk it out. I like to learn, as you guys do too. So I'm excited about this conversation. Let's get to it. EDB, you're back.
Oh, yes, it's so good to see you, Peter. Also, I had the same thing where people were saying, LYK, also, it's so easy with the initials. LYK said this and LYK sees it that way. I'm like, I love it when we see things a different way because we have different work experience, different experience with this case. And lawyers should all see things differently. And even if we don't, we can find something to see differently just to have the conversation, which is what I love.
We must hate each other if we see things differently. That's my favorite part about it is they're like, uh-oh, you see this different than Emily. I'm like, that's probably going to make it fun for everybody to watch both and kind of see the different ways to look at it. And every single case, every single trial, there are two lawyers that see things very differently. Some people like the judge's ruling, some don't. But you covered this case long before the trial started, right? And what got you into it? And did you stream like every hearing? Did you go through the documents, everything on this case?
Everything on this case. I started covering it in June 2023 after Kouri Richins' arrest. When she got arrested, people were like, she wrote a children's book about grief and then she got arrested for murdering her husband. I was like, what did you just say? Because if you write a book about something that's going to be used in court, I'm immediately in. I felt the same way with Keefe D. He wrote the book about the death of Tupac, among other things, and is being prosecuted in Vegas. If you write a book and then it's going to get used against you, I'm going to get pulled in because I'm immediately curious. And then at the bond hearing or bail hearing, I don't remember which it is in Utah, but at the hearing, so many details came out about the case. And I was like, wait a second, there's a big financial motive here. There's a sister-in-law who gave a victim impact statement at the bond hearing talking about needing 4 people to pull Kouri off of her, like 2 days after the death of Eric Richins. And then there was a year between when he passed and when she was arrested. I was very curious and I was immediately pulled in and covered. And I mean, once the judge started ruling, I was like, and you've got a young judge with a great voice who seems incredibly competent. You've got a prosecutor who is clearly a seasoned litigator named Mr. Bloodworth, who is just as calm as can be. You've got Sky Lazaro, who is like 6'5" in court with stilettos. I'm like, I love everything about this case. And I was riveted. And then covered the docket, covered all of the hearings, covered the preliminary hearing. They did a 2-day preliminary hearing with quite a lot of witnesses. And once that walk the dog letter hit the docket in September, I was like, you've got to be kidding me. This is incredible. I love everything about this case, which is hard to say about a murder case, but I am a former prosecutor and it was fascinating.
It piques the interest, like a show. Like anybody that likes to watch a show that's also sad or also has scary elements, like that's what this is. As you watched everything, so if anybody wasn't able to cover everything or watch everything before the trial started, go back and you can watch Emily's breakdown of all of that, because I think it'd be interesting to watch now in hindsight. How much, I mean, it's hard to put a percentage on it. You can just say kind of a lot, a little, or somewhere in between. How much came out in all of those hearings and things you looked at pre-trial did not come in at trial?
Oh, percentages are tough, but at least 25%. It was at least, if not more. There were a lot of things that came out pre-trial that did not come out. And I think that this case, more than others, because I actually went back and revisited yesterday. Actually, let me give you the date because that'll be easier. On March 18th, I went back and revisited the bond hearing to look at what I had forgotten that I knew. And there was a lot that didn't come in at trial from that hearing. And people were like, why didn't this come in? And it was a really great way to have a conversation about that actual balance between probative and prejudicial. And in this case, I think you can see that balance really well. I'm like, none of these things help you decide if she murdered her husband. all of these things make you look at Kouri Richins and go, that's a person that would murder her husband. And that's why it doesn't come in. And so there was a lot pre-trial that didn't come in. There were things that developed a little differently than in pre-trial because there had been subsequent interviews and one of the witnesses had changed their mind about the substances they were selling. And then there was just information because a lot of it was hearsay that didn't come in. So I knew a lot of what Eric Richins' statements to his friends purportedly were, because that was all really, really thoroughly litigated by good attorneys, both sides. But the defense won a ton of early motions going into trial to keep things out. And I think, though some of them I have legal quibbles with the judge, but I'm not the judge, I think the judge erred every single time on the side of caution and protecting the record. And so more was kept out than I necessarily anticipated, but it was interesting to see. And I mean, I was a prosecutor for over 10 years. You're used to knowing more than the jury does and balancing those two things in your mind of what do they know and what do I need to show them versus what do I know to be true.
So how did that affect you going into this trial? Because I had read up on and seen some of the stuff, the walk the dog letter, and the financial motives and writing of the book and things like that. I had seen a lot of that. So I assumed there was going to be a pretty quick and easy guilty based on all they had. It was going to be the generally bad gal rule where everything was going to come in and people were going to hate Kouri Richins, especially the jury. What was your thought before the trial began of how you thought it was going to go?
I think the murder count was always the strongest in my mind. They didn't charge the attempted murder until more than a year after she was arrested. So the case actually developed quite a bit after arrest. They paired out a ton of the financial information. There's actually a second prosecution trailing this one with 26 different types of fraud counts and money laundering counts. So there's a whole tail of financial stuff that in the Murdaugh case all just got lumped in, which I think is going to be a problem. But in this case, it was really curtailed down. But coming in, I was always on I see how this case connects. Like, you're not trying to build this case for me in opening statements. I already see how this case connects, but I was curious how the attempted murder and the forgery and the pared down fraud counts would come in. But I saw the through line. I think the prosecution did a really good job of tying that together in opening. And then there were still times during evidence where I was watching people watch with me the first time and they were like, wait, did they talk about insurance fraud? I'm like, oh, it went by quick. Like, if they don't tie this back up in closing, some of that evidence, it was kind of flagged in my mind because I knew what I was looking for. But if you're just sitting there watching, you're like, wait, what's that go to? What's this about? And so I think closing arguments in this case more than most might have really mattered to tie those things together that went by pretty quick. And I think the defense did a good job of trying to pull focus into other directions so that maybe the jury didn't see some of those things. And the jury was like distracted about weed gummies and not looking at the through line between the murder and the attempted murder.
Yeah. And that's something that, was hard to kind of visualize throughout the trial from my perspective is what evidence do they actually have of the attempted murder besides the murder? Because without that, it's just never something you'd ever see prosecuted on its own based on the evidence that they had, which again, in my opinion, I should say, so I want to kind of ask you about it. Is it something that you could see based on the evidence they just have of the attempted murder without the murder? Is that ever something you can see them going forward on? If you were going to prosecute something like that with he ate something that she gave him, even if you have the Carmen discussions about the drug deals, maybe he got sick, maybe he didn't, because it's interesting you say that what his friends told him was heavily litigated because it was so pared down. I mean, it almost proved nothing. It was like, I have never seen him this upset except like when his mom died. It's like, so what does that mean? And the O'Driscoll never even got evidence. Did he go to the hospital? Did he not go to the hospital? Did he use his EpiPen? Was it a kid's EpiPen? Like, would an EpiPen even help if he took fentanyl? It was just like this stuff thrown out there that I feel like was no proof at all. What did you think about the attempted murder charge?
Well, the two parts, Peter, compound.
It was like 6 parts.
I've never tried an attempted murder case where the victim had subsequently passed. So if they were going to try this in a vacuum and Eric Richins hadn't died, Eric Richins would have been able to come in and testify about everything that happened. So I don't think the attempt in a vacuum is easy to evaluate, because then you would have the things he said to his friends and you would have his concern, his level of fear, and him trying to figure out what he's going to do because he suspected that Kouri had done something to his sandwich and had done something that made him that ill. The evidence came in really quickly about the pseudo allergic reaction with opiates, but it was something I had been waiting for in the trial. So I was like, both ears perked up. Though if you're not looking for it, that evidence went by really fast on the type of allergic reaction he had. I think for me, the witness not stakings, singular, not plural, who testified that they were kind of all just jokes about, oh, Kouri tried to poison him. You start to get a little more context around what the friends said. And then when the friend kind of looked at Kouri and was like, I mean, we were all just saying, don't eat what Kouri gave you, and kind of joking at Kouri. In a different circumstance, that might be, yeah, jokes, but a jury sitting there looking at that is like, oh, so he was telling people that she tried to kill him. And this is after he changed his will. And then she asked Carmen Lauber for something stronger. And that evidence went by kind of quickly too, because I think the defense did a pretty good job of distracting the point in Carmen's testimony and pointing out where her story had changed and where her memory was fuzzy and where the time and dates were tough. But I think by the time you got back to closing and he's like, Valentine's Day happens, Kouri asks for something stronger, and then Eric Richins has so much in his system. I think you tie those together. But yes, you look at the murder backwards and then you start to see the dots connect on what Kouri was doing. And then when you get to the lies about where she was, and if my spouse was like, hey, I think I need to go to the hospital, and you know that they're picking up your kids that afternoon at school and at sports, you're going home. I don't care what you're doing. You're going home. And she's still with her boyfriend. And she's like, oh yeah, I'll be there shortly. And then 3 hours later, she's still not home. That behavior doesn't track for a lot of folks who would be like, no, if my spouse is telling me that they're not feeling well and they might need to go to the hospital, I don't care where I am. I'm getting home, especially if they're going to be driving the kids. So I think those things for me tied together, but also I was looking for them, which is why I went into this case saying, I know a lot about this case. And so my perspective going into this case is, how does the evidence come in? But I also know what the world of evidence looks like. So it's a little easier to flag the things that were important to me differently. But I connecting those dots on the attempt made sense in my mind, just how everything unfolded. And then that digital evidence tying Carmen's buys to the dates. Even if you discount everything Carmen Lauber said and just go, I don't know what to believe, the dates of those drug buys are pretty damning.
Yeah, you have to have the stuff after, because in my opinion, without the I need something stronger, the Michael Jackson stuff, maybe she said fentanyl, maybe she didn't. All that's after the fact. We don't have any evidence, even if Eric was alive and he was testifying that, he thinks Kouri did it. There's no stomach contents.
Hard.
And he didn't call the cops and say, my wife poisoned me. So there was lovey text, there was all sorts of context, I think, to that makes it a pretty weak charge that never would have been able to be brought without, of course, the fact that she was able to finish the job later, which again is wild to think if they were all talking about don't eat anything Kouri gives you because she tried to poison Eric and then she actually does poison, which kind of seems like a stupid criminal, which doesn't cross her off the list because there's plenty of those.
The fraudsters think that they're the smartest people in the room. And I refer to her that way because the fraud behavior that led up to all of this, like Tom Girardi, like Alec Murdaugh, and like so many of my own cases, that pattern of fraud behavior, they always convince themselves that nobody's really clocking their behavior, and that if people are just smiling to their face, that they've kind of convinced everybody. And people were, yeah, exactly. And they were still giving Kouri money. Like, her investors were still giving her money. She thought that this was all rolling. And it's rare to get a fraud defendant that spirals out into a murder case, but it's not unheard of. And it's not even something we haven't covered before, because Murdaugh was that way too, though I think the motives here tied together more cleanly than they did in Murdaugh.
I got my first term life insurance policy when I got married, and I got another one when I had my first kid. They were so incredibly cheap at the time, and the peace of mind that they've given me over the last 15 plus years is really invaluable. But the process isn't always quick and it's not always easy. And that's where today's sponsor, Fabric, comes in. Fabric by Gerber Life is term life insurance you can get done today, made for busy parents like you, all online on your schedule, right from your couch. You could be covered in under 10 minutes with no health exam required, which is so much easier than most companies make the process. If you've got a spouse, if you've got kids, if you have anybody depending on you, term life insurance is something you should seriously consider. If you're young and or healthy, which is when I locked mine in, it's so much cheaper. So now is the time to lock these rates in. So join thousands of parents who trust Fabric to help protect their family. Apply in just minutes at meetfabric.com/LYK. That's meetfabric.com/LYK. MEET fabric.com/LYK. Policies issued by Western Southern Life Assurance Company, not available in certain states. Prices subject to underwriting and health questions. Yeah, no, and we have countless examples of that. We tried a case once, Pete and I, of a guy that was basically stealing money from his dad's investment accounts when it was all going to go to him anyways. And what did him in was a recorded conversation with Fidelity, basically being like, if my dad calls, don't give him the new password. You know, it's like things like that, where it's like, it's working, dude. And you just took it a step too far. And, you know, sometimes that's how it all comes unraveling. But the forgery specific count with the signature to me was also incredibly weak. The evidence, the actual evidence. Like, do I think that Kouri probably did it?
Yeah, that in a massive fraud case would be easier, but the court had separated out a number of other counts really early on, severed out a bunch of counts in the 3-4 counts in this case. They're all in the subsequent case with a lot more information that came in during the investigation of the trust and the litigation there. But the forgery and insurance fraud would never be tried on its own. It would go with either a larger fraud scheme or with this case because of how close in time it was. I think the prosecution's argument that, look, if Eric's signing this after going to all that effort to create his trust, you put that insurance in the trust with everything else. I thought it was a really good point. But again, standalone, those 3 counts are not going to trial by themselves. They're part of a bigger plan, and they're part of the dots that need to be connected to make everything make sense in context, because otherwise the defense's point is pretty salient. Like, you know, happy people just don't kill their husbands to steal from Elle Woods, but he's worth more to her alive than dead, though I have some thoughts on that. But the defense's point of why do you just kill your husband who's making all this money? It needs that explanation so that the jury can understand. Did you see the 4-person's interview?
I read like an article about it. I don't know if there was a long interview. I saw some like little snippets. I didn't see it. Okay.
But the 4-person, I think, highlighted some of this as well, where the 4-person was talking about how they really didn't want to convict her. Like, they did not want this to be true. They, I think, went in with the approach that you talk about so much. I probably don't talk about nearly as enough or as much, but we went in really wanting this to not be true. We didn't want to convict her, and there was no other option that they saw. And I think that kind of speaks to closing arguments a bit, and probably opening arguments too, but people don't want this to be true because it's just too awful to think that the person that you've married, had children with, and sleep next to every night would do this to you.
Yeah. That was why the fraud one specifically to me was like, it's probably not Eric who signed this. Nobody says it was Kouri who signed this. And just like, to me, it's like, that's not, if I brought that to you, okay, lead trial assistant Emily Baker, I think we should, you know, indict this person. Here's the evidence I have. You'd be like, that ain't enough. It's just not enough. You need more.
It's not, this by itself doesn't make sense. But
yeah.
I really was surprised in closing that the defense zeroed in on, you don't know that she didn't have permission to sign it. I'm like, oh, so you agree that she signed it then?
Right. I agree. That was stupid.
It was like, oh, you agree. So I don't even have to think about that. You agree she signed it. They also, I think, kind of acquiesced on, well, she was buying things from Carmen Lauber, but she didn't know what it was. It's like, she thought she was giving him enough to kill him. It doesn't really matter if she knows what it is at the end of the day.
Yeah.
So why are we acquiescing on, well, she was buying stuff from Carmen, but he might have needed it. She had prescription bottles left over in the house. Why would someone go onto the street to get something that could be laced? when there's prescription pain medication still in the house? It doesn't make any sense. But I also was looking at those details because I knew the broader story, and then you can zero in on the details a little easier.
And that's where it can get confusing for, I mean, these defense attorneys are very experienced, so I'm not saying anything they don't already know, but asking questions to a witness is very different than the arguments you make in closing. So it's fine. Like, you don't have any reason to believe or any evidence that Eric didn't allow Kouri to sign things for him, to sign his name for, those are totally appropriate questions. But yeah, it's just very simple. You take out, even if you just want to win one count, you take out what reasonable doubt is, and you take out what the burden of proof is and the elements. What did they actually prove? They proved it probably wasn't Eric. That's it.
Right.
And probably isn't enough, right? And probably Kouri isn't enough. And they didn't even say that. Like, to me, if they would have broken it down in a more simple fashion, it wouldn't matter, because if you get convicted on the big one, then nothing else really matters. But I think they could have come up with some really good arguments for the attempted murder and the that forgery insurance fraud part, because especially like, look at all the evidence they have of the murder. They got nothing compared to all this. It's like that doesn't help you unless you're just a lawyer trying to nitpick and win some of the battles. But what did you think overall about the lawyering? We got to get to that. I know it's always a big thing. I'm sure people ask you. We are lawyers, right? So what did you think of the prosecutor, defense attorney, judge? What was your kind of analysis of that?
Well, I mean, I love Judge M. There's no level of understating my love for Judge M. I was critical at times because I thought he was overly acquiescent to the defense. There are times that I thought he was overly cautious, but also I understand a bench officer protecting the record, and it was very clear that that was on his mind. I love that he would rule from the bench. I love that if he needed 5 minutes, he would take 5 minutes, collect his thoughts, come out and lay out a ruling element by element and his findings. I mean, his records, the appellate courts have to love reading his records because he lays out his findings so orderly and so clearly. And I saw him on more than one occasion bring up sua sponte case law the defense hadn't cited that was in their favor, and bring up things that he found as a bench officer, and he talked about considering them and how they played in. I thought he is definitely in some of the top of the judges that we've watched, and the level of discernment was appreciated, and also the rulings and how thoughtful they were. There were times though that he would let the defense keep arguing, and he wouldn't necessarily change his mind, but he would let them kind of go round and around and around and around. And I was like, are we done yet? That you've ruled like 4 times on this, and you ruled in motions in limine. Can we cut it off now? Are we done? As a prosecutor, I would have been really frustrated because there's a jury in the hallway during the prosecutor's case in chief, and the defense is going around in circles for 2 hours to get back to the exact same spot. And that just pisses off the jury. And I think sometimes they hold that against the party presenting the evidence. And that was tough for me. I was like, just cut them off sooner. I think many have critiques of the defense. I do as well. I do not think they were lacking strategy. I do not think that they are missing the point. I just don't. Their strategy is not my vibe. It's not how I like seeing cases presented, but they were dogged in going after things. They raised every single motion. And if you're going to look at, hey, it's our job to raise every issue, they left no stone unturned for their client. They went after this case, and they were appointed in midway through. They came in after the walk the dog letter and after some water under the bridge. They made a lot of headway with motions in limine. I mean, they tried to get the judge to change his mind on a few, but they made a lot of headway in those motions and had a lot of really significant wins in those early motions. But the trial demeanor was difficult for me. I would have liked to have seen them focus in on really the big points and the weaknesses instead of throwing it all against the wall, because then you can miss it. I was not heavily persuaded by the artwork in closing and the Monopoly card. I thought it was ill calculated. And there were times when they were following threads that I was like, you all watched the Karen Reed case. It was very clear to me that they followed that pretty closely in the way that they talked about things. There were some things I think they directly borrowed from Alan Jackson's closing in that case. And there were some ways they tried to attack this case, and they're not the same case. And it was tough for me to sometimes follow. And then they would have crosses with like really good points. And then they would keep going. I was like, no, stop now, sit down. You've made your point. Now you're making it worse. And I thought the prosecution team was methodical. They were organized. Their digital presentation was one of the best that I've seen. And I think that their tech expert and their financial expert, they walked through the evidence with enough detail, but without getting into the weeds, which is a hard balance. And they tried a very trim prosecution, which takes experience. It takes a little bit of intestinal fortitude, and it takes confidence in the jury that you picked to really try a tight prosecution. And I think where we saw the prosecutors in both Reed prosecutions go wrong is they were playing whack-a-mole with the defense. This prosecution seemed to have blinders on to what the defense was doing and just followed their case and tried their case. And then the defense is going to do what they do. And then if they need a rebuttal, they'll bring it. But they kept it narrow. And I think that not all prosecutors would have done it quite the same. But the more that you put into your case that you don't need, the more there is for the defense to work with. And I think that was a strategic call from the prosecution as well. I thought the lawyer was great on the prosecution end, but I'm a fan of Brad Bloodworth. I liked him as a prosecutor. I liked the balance of him versus the defense, because when they would get more animated or agitated, he was just kind of the calm voice in the room. And a lot of the times the court would kind of state a point and defer to the prosecutor and say, have I accurately summed it up? He's like, you have, Your Honor, and just sat back down. Just great trial strategy. And I think the jury probably looked to him to make sense of things, where in other cases we've watched, particularly the first Reed trial, I was waiting for Alan Jackson to say something so I could understand what was going on. I was like, what, can somebody make sense of this? And I think when that's the prosecutor, that's a huge win for them.
Yeah. So I took some notes while you were talking because I want to hit judge.
That's a lot.
yeah. No, that's what I asked, right? That's what I asked for. So judge, I agree with you. And it's funny, you kind of had to tell where it was like anything else from the defense. It was like it was over, but if you wanted to say anything else, now is kind of the time. But I loved how I disagreed with a lot of the decisions that he made kind of throughout the trial, little ones, nitpicky here and there, but I understood why he made every single decision. He made sure the record was clear. He did his own research and he did what he thought was right. And he did it in a pretty quick fashion, which is all I can ever ask for from a judge, is make a decision and make the decision you think is actually right, not for any other reason than what you legally think is appropriate, which I think he did.
I you didn't watch pretrial. Sorry to interrupt.
No, go ahead.
But the defense had made a motion really early on about the number of jurors, because unless it is a DP case on aggravated murder in Utah, you get 12. And when the judge was making his record in that motion, he really kind of showed his hand on where he's at. And he said to the defense, I am following the law as it is today in the state of Utah. And he said it, he goes, I hope too that one day our legislature will take this up. And I do think that there is a lot of valid reasons to have 12 jurors, but my role in this case is to follow the law as it is today. And it's very clear to me that this is why 8 jurors is exactly what the law says. And I hope that it changes. And then I would be happy to change my mind. And I appreciate how he would also acknowledge the argument the defense is making, acknowledge why they're making it, empathize with why they're making it, and say, it's my role to follow the law, not to change the law. And I appreciate that from a bench officer too, because it's nice to see where he's at as well, and to kind of remind the defense, hey, go to all those association meetings and tell them to change this.
Yeah, no, absolutely. And feel free to interrupt me. It's a much more interesting conversation. I just wanted to make sure when you were on a roll, I took some notes so I could respond to some of the stuff, because the defense, a lot of what I was hearing is people thought that they were lazy or unprepared or not even trying, or trying to, lose on purpose to give her a good appeal with ineffective assistance of counsel. That's just not what that looks like. If you want to see what a lazy defense looks like, or a defense that's unprepared or really ineffective, it doesn't look anything like this defense. The presentation was bad. It was not becoming. They were not going to win any fans. And I actually think Bloodworth was likable, not in like a jovial David Yannetti or even a Leslie way. He wasn't likable like that. He was like the boss of the courtroom. It's like dad or CEO. The way he dressed, the way he looked is just like that kind of screamed professionalism, which jurors like and kind of expect from lawyers. And so I think he absolutely had that over the prosecutors. I also think that at times their case was a lot easier to understand than some people may give them credit for. And we've seen other trials where it's miserable going through cell phone evidence or DNA evidence or whatever, where they're calling everything by a number and you have no clue what they're talking about. I thought they did a good job being like, okay, this is Carmen's phone and this is this person's phone. So just simplifying it, which you can once you lay the foundation.
Yep.
Lastly, I thought that when you said they didn't respond to what the defense did, I agree with you for the most part, but I think they got way down the THC gummy runway. And then it kind of all went away the last week of the case. I feel like we didn't talk about THC gummies at all, which I think again hurts the credibility of the defense throughout the case. The only knock I would say on him is I don't know that I think Judge M by far had the most mastery of evidence of everybody in the courtroom, which is, you may think that that's normal for judges. It's actually not.
Not at all. Yeah.
But that was, I thought that some of the evidentiary arguments were a little bit weak and they would just miss the right objection or the right argument.
There were definitely times that Judge M would bring everyone back to the most salient point, which is much easier for me sitting at home, not in trial, because I know when I'm in trial, there's times where your brain is just latched onto something and you're not even thinking about step 3, 4, 5, and 6. You're just kind of in it. But Judge M did a really good job of bringing it back to the main point and keeping his eye on what is the standard, what is the law, what do I need to prove, how are we deciding? And what people may not appreciate about judges is that the judges only have what the attorneys give them. Their case file is the motions. And so there were times when Judge M is like, I need you to show me what you're talking about. And not all judges will do that, but judges do not have the prosecution and defense discovery. They're sitting there with what's given to them. And he did a really good job when he needed more information. There were times he changed his mind. And there were also times in front of the jury where he pulled all the onus onto himself. He never put it on the parties, even when I thought he was frustrated with the parties. But it was always I have a scheduling issue, which I don't think that he did, but I need to handle this. I need to take this time. And I think his courtroom comportment was kind of the exemplar of judicial temperament. And I thought that was great because even when there were times he was definitely frustrated with the defense, and he would say to them quite a lot, stay focused, which was hilarious to me as the least focused person when I cover trials. But he was like, stay focused. I'm like, I am trying, Your Honor, but there's a lot going on. But I love that he would bring it back to the point. And even when frustrated, it never impacted his ruling because he was clearly frustrated with the defense at time and would still rule in their favor. Not all judges navigate that as well. And we've seen that in some cases. I best compliments to Judge M. My biggest beef with him is how much he really didn't want the media in his courtroom leading up to this trial, which made it kind of frustrating. I'm like, but Your Honor. My joke with the law nerds was that his wife was like, I see everyone on the internet talking about you and calling you Judge Daddy. We're not streaming this trial. We're not doing it. The entire internet is like, hello, sir.
I hear it. I hear it. I'm sure that he ignored all of that, but I actually think he was a really good example of why cameras work in the courtroom. If you handle a case in a trial in a courtroom the way that he did, especially his announcement at the end before the verdict was read, I just liked the way that he kind of handled it throughout the case. So yeah, he's one of my favorites that we have seen in any of the trials that we have watched. But there was a bunch of kind of wild witnesses and things that could have made this trial go off the rails. And I think he kept it on the rails, but I did want to talk about some of the themes of the case because it was really interesting to see different people's perspectives on this. And when you have a jury of a bunch of different people that don't know each other, the chances are people are looking at evidence multiple ways. And one of the big themes was the Richins family, right? The sisters, the brother-in-law, their money, they're controlling, they're trying to get the accountant and the private investigator, and they're paying hundreds of thousands of dollars. And they said from day one, Kouri did it. They targeted Kouri. They made sure it was Kouri. Some people did not love the sister's testimony. And, a lot of the evidence that came out. What was your kind of feel? And then the juror, one of the comments I saw from the foreperson is the Richins family drama or whatever. And she kind of felt bad for Kouri in the beginning, which I thought was interesting. What was kind of your feel on that?
I was largely surprised, especially since I do think the defense team followed the Karen Read cases pretty closely. I was surprised that they did not follow the theme of Kouri was an outsider. Kouri is not from this community. And we had seen that in early pretrial with Sky Lazaro. Kouri was working at Home Depot when she met Eric, and he comes from this wealthy family, and they've got their own ranch, and they've got a very close-knit family, and she was the outsider. And so, of course, Eric's not going to necessarily talk to his family members that might be going to church more about the weed gummies or the drinking. And so Kouri was kind of the black sheep. I think the defense probably had to navigate the unredacted walk the dog letter, because if they went down that avenue too much, it opens the door for that unredacted parts of the walk the dog letter where Kouri talked more about her sister-in-laws. So I think there's times when I'm like, why didn't the defense do this? But then I also remember that there is this weight of other evidence that they could have opened the door for that they really didn't want to. So
it's the same thing with that witness they were going to call, and the judge was like, well, then I'm going to have to let him bring the full context. I didn't know specifically what he was talking about, but I could pick up what he was putting down.
Yes, that was not an opening the door. That was actually removing an entire wall of a home. That was not a doorway. And it was, we want to bring in this person who had this conversation with Eric Richins and to show that the investigation wasn't thorough, that you didn't consider it. And it's like, and I can see why they wanted to go there with O'Driscoll, because his conversant knowledge of the case was lacking when he testified, to put it kindly. And I don't think it was the same as a Karen Reed case. I don't think it was malicious. I don't know if it was inexperience or...
We're gonna get to him. I got a lot of questions for you about him.
But when they're talking about attacking the investigation, and the court actually went back and looked at the case law and was like, actually, the defense cited none of the things that the court said. But the court went back, did his research, and was like, actually, if you want to attack the investigation with things that were kept out in pretrial, you can. However, the other side of that coin is all of this other evidence that has also been kept out. So tread lightly, because the other side of the evidence included a recorded jail call from the day that Eric Richins died between Carmen Lauber's best friend who was with her on the hand-to-hand transaction and a guy in the state prison, and talking about, Carmen will handle it. She's got a lot of money. She's been selling fentanyl. So there's these other things of, well, why didn't the investigation follow this lead? Well, because of all this other information, and all of it was kept out. So yeah, I thought the judge was great in that. And I know we were talking about something else, and I totally steered
with the Richins sister, and I feel like
yes,
you're the perfect person to ask, like, did you get mean girl vibes from them? Did you feel like the jury was going to? Because I felt my initial reaction was, I feel bad for them. And I talked to my wife about this a little bit because she followed the case, and she was like, I would despise Kouri Richins if I was in their position too. And all this had happened leading up to the fact. And if I really thought she tried to poison my brother, and then if I thought she actually successfully poisoned my brother, those poor kids, I would want to take those kids, those are my nephews. So like my wife was, in lockstep understanding how they were feeling. But I also heard in the chat, some people seeing it opposite. Like, were you getting any mean girl vibes, or what were you feeling?
I knew too much.
Okay.
I could see where they have to be careful depending on who's on their jury. And this is where we have a little bit of a blind spot, not being in voir dire, which is hard, because when you voir dire a case, you can look at arguments and be like, not this argument with this jury, or yes, this argument with this jury, because their experience, their life, if they are married, if they have kids, what their jobs are, more about them. And I can see where you needed to tread lightly, because not all of the backstory was coming in. But for me, listening to Katie Richins testify, she came across less angry than I anticipated, because there has to be a deep level of anger there with everything going on in the civil cases, with how much they had to fight with DCFS and the rest of it. But I think playing the 911, juxtaposing how Kouri and Katie reacted, really grounded that grief for the jury. And there were parts of Katie's testimony that I hadn't seen in pretrial, that hadn't ever come up, that Kouri had a plan to run Eric's business, which I have a lot of thoughts about, that she had a plan to sell the house, that she had a plan to do all of these things. But I can also see where the jury could see Katie reaching when she's like, oh, Kouri, was in a matching set and had put her hair up and was trying to be.
Yeah, that was a reach. Yeah.
Right. And so there were times when I can see jurors who might not resonate with her, thinking that she's reaching just to make Kouri look bad in some of those moments. And while some jurors might be like, of course she's mad, so I don't care, other jurors might be like, but are they trying to set her up because there's a disgrace if he took something that was tainted and died by accident, and we don't want to taint his memory? So I could see how it could go both ways, but I think the body cam spoke maybe louder than the testimony did.
Yeah. And I also felt like they weren't like the dad and sister, I don't feel like were huge witnesses in the case, and I think putting them on early was smart. It kind of gave them a background, who Eric was, that they didn't like Kouri. So, I mean, I think it worked. I think it was a smart strategic decision to get them first. Because if they were awesome, it would have been good, but also kind of forgot about them by the end.
Yeah. And to really limit what they used those witnesses for, kind of the key moments. I think that Attorney Bloodworth knew what he wanted his closing to be and very strategically picked those questions and nothing more. It was, we're getting this, we're getting this, we're getting this, and it all ties together later. It was a very methodical prosecution. There wasn't, I think, a ton of extras, and those extras came in cross-examination, and there was room for it. But I think at the end of the day, the 911 being replayed is kind of closes the door on, the Richins family is just trying to smear Kouri, especially when you start seeing what she did with Chelsea Barney's house. I think that that kind of changes that narrative a little bit.
It's funny to think of what she did to Chelsea and how horrible that made her look, and think Murdaugh did that to like 1,000 people. It was like they had story after story after story of him doing that to these people. Okay, so I think the most important witness in the case was Carmen. And I think that she had about every credibility issue you could possibly have for a witness. And I can't really fault the state for trying to deal with those or her coming off not credible. This is not a scenario where I think the state's putting somebody up on the stand that's lying. I'm sure you don't think that either. No. And I also absolutely love the fact that Bloodworth was like, I didn't choose Carmen Lauber. Kouri chose Carmen Lauber, and we brought her here because we're here for the truth. I thought that was A+ in closing, bringing it around. But what did you think of Carmen's testimony?
I was surprised that the cross-examination made her as sympathetic as it did. The cross-examination
lawyers could do that.
Yeah, the cross-examination made Carmen Lauber really sympathetic, and I think that undermined some of the real issues there. I was stunned at some of the things law enforcement said to her. I was like, why? They're sitting there just like spread out in the interview room, and they're like, you need to give us the facts to convict Kouri Richins. I'm like, why the fuck would you say that? What are you doing? What are you doing in this interview? But I also think when the state expanded, when they embiggened for completeness those interviews, you got a little bit more of a vibe, and it wasn't quite as bad as the defense made it seem. I still think it was.
I don't think it was worse to replay it because we got to hear the get out of jail free card. We got to hear the cops saying stuff like that, and Carmen just sitting there like, sure, I'll give you whatever you need. There's also just like an element of this happens all the time. People flip and testify against people. Like, yes, it's a get out of jail free card. It doesn't mean she's lying. But again, the way they said it was just so annoyingly stupid, the cops, that it was like, why do you guys do this? It did not have to be like this.
No. And Carmen knows what it is. I mean, it's very easy to go into an interview and be like, look, we searched your house. We know that you know Eric Richins. We know that you cared for him. We've got your phone. So are you going to tell us what you know or not? Because if you do, it can help us and we can help you. And if you want to get through drug court, we're here to support you. But if you don't want to talk to us, don't talk to us. And then you leave and let her think about it for a few days. Because she did seem to feel quite a bit of remorse. It did seem like that death when I 100% believe she called Kouri and said, was it the pills that I sold you? Because that tracks with so many involved with narcotics and street narcotics and narcotic sales that they're like, I don't want to be pinned to somebody's death, not only for their conscience, but also for getting prosecuted for it. So I think the defense made Carmen more sympathetic than I anticipated she would be. I think without the digital evidence, this would have been a very, very different case. And I'm glad that they were able to get to the digital evidence that they could. I also think it was unfortunate that everyone deleted texts on each side, but it was also telling. But I had a boss at the DA's office who would always say to us when we were looking at difficult witnesses, he's like, the witnesses that you get are happening and existing where these crimes are happening. And when crimes happen in hell, all your witnesses aren't going to be angels. That's just what it is. And it stuck with me throughout my career that, one of my first criminal trials was a no victim robbery case that happened during a drug transaction. So the people who are around and witnessed it. We're all also there to buy drugs. And it doesn't change what happened and that it shouldn't have happened and that the police did get involved. And it really is where I have some understanding of where Crozier and Lauber are at. But again, that's DA understanding. Not every juror is going to sit there and look at Carmen Lauber and be like, I mean, I get what the game is. I get where you're at. I get where you're distancing. But I thought she was a lot more sympathetic than like Juliana Mogulhays in the Banfield case.
Yes.
So.
Yes, but I think Juliana was way more credible. Like I felt like everything she said lined up pretty perfectly. It was hard to even say anything against what she said. The evidence lined up exactly with what she said. Sure, she could have gotten fed that too, but she was so unlikable. Carmen, I feel bad for her. I think when she came up the second time, there was also sometimes I felt bad for her, but then also like she's kind of stone cold, at the same time. Like you could feel a little bit of that, like she's going to do what she's got to do to protect herself. And I just feel like not enough of that came out. They had such amazing quotes, the defense, that if they would have just built it all around that, say she admitted her brain was fried, like you don't need the whole, you have a learning disability and all. It's like, you have the get out of jail free card. Like she was going to do what she needed to do. It was to me just a fumbling of something that was really good. Now, somebody like myself who, is a lawyer picking up like, okay, yeah, this is not a credible witness. But I think the jury looking at it is like, kind of feel bad for her. Why are they acting like this? She didn't choose to be here. And we hear about imperfect victims, witnesses that are also drug dealers. That's pretty much par for the course and what you expect. And we got that even more from Robbie, who was not sympathetic, flipped his story, and the state had to deal with that. I thought they had to call him because if you don't call him and the defense calls him, it looks even worse.
Yep.
What did you think about the way that went? And then the state later playing his actual interview?
I think the defense made their case more difficult in the wild treatment of Carmen versus Robbie. It was so different. It was such a wild switch up. And I don't understand why the defense tactic wasn't to lean into Carmen being empathetic and leaning into the cops being shit. Just lean into, hey, I know you got to do what you got to do. Like, I see you. You got to do what you got to do to get through drug court. But look at what these cops did. Look at how they were manipulating you. Look at what they were saying. Look at how they were piecing it together. Like, I get why you took the deal, but they fed you all this. And that's not your fault. That's their fault. Like, lean into how bad the cops are and stay with Carmen being empathetic. Like, you're going to do what you're going to do. And then to go after her and make her more sympathetic, and then to like beam at Robert Crozier and just be like, oh yeah, those typos, I typed that up for you to sign. I was like, I can't listen to you anymore. Seriously. Counsel, what are you doing? You're filleting one witness over, oh, you wanted them to write this out for you. And then you're beaming at this other witness like he's your new bestie because he changed his story. And then that video really highlighted the difference for me, which I think undercut the defense's credibility to where the jury might have just been like, I can't listen to anything you're saying. The phone transactions make the most sense to me. I'm listening to none of it.
Yeah, that I think was the key, was the phone pings, but and that's what the juror said as well. But I also thought that it was a great example for lawyers or people looking at what makes a good lawyer, bad lawyer, more skilled or artful lawyer. When you make a mistake like that in an affidavit and he's got to come in trial and everything on something you want him to say is true, he has to say, well, this isn't true and that's wrong and I got to cross that out and everything is true except it was this oxy and not that. It just is so much more clunky. It's so much worse of a presentation. And I think it hurts the point you're trying to make so much, which was a microcosm of kind of the defense of the entire trial where they had something good, but then they kind of go and muck it up basically.
Yes, they overplayed their hand, I think. And the disparity in treatment was something that I was sensitive to because it frustrated me to watch. But I can't imagine that the jury wasn't like, wow, that's a wild change in demeanor, which is, again, why I was surprised that the defense didn't lean into, they're doing what they got to do. This is all part of the, they're doing what they got to do in the system. The cops are really the problem. They're the ones feeding everyone the story to get to Kouri, instead of like, well, Robert's great. And he wasn't even selling fentanyl then, except then he testified that at the time fentanyl looked exactly the same and he was charging the exact same price. So I think some willful ignorance on, he's like, I didn't even know what I was selling it. I'm not saying it's fentanyl. I'm not saying it's not. But knowing that video's out there, they really tried to, it seemed, put evidence in isolation and not consider everything else that was going to come in. And I don't think they thought that the state was going to use the rule of completeness in Utah to such great effect. But the rule of completeness in Utah is actually pretty broad versus some other jurisdictions. And it allows for quite a lot to come in, and at the same time, if the parties request it. So I think when the defense wanted to just play snippets, they really allowed the prosecution to make more of it. And that was interesting to me as well.
Yeah, that I thought he was like giving him too much on the rule of completeness, but that makes sense that it's a little more broad there.
It's a really broad rule. I think either side, it's friendly to either side. It's pretty neutral, but it's a broad rule, and the defense had to have looked at that. I mean, maybe they didn't consider how strategic the prosecution was, but that is just such a massive miscalculation to not look at Attorney Bloodworth and go, that he's going to see all the pieces on the board and play them to his best advantage.
One thing I just thought about, kind of like with the totality of dealing with all of this and what Bloodworth kind of did at the end, but I don't feel like he did at the beginning and throughout the trial, is I would have just gone more with Kouri poisoned him prosecution versus Kouri specifically wanted fentanyl to kill Eric with fentanyl. I think that made it more confusing, made it seem like they didn't really prove it, or seemed like more reasonable doubt than maybe there even was, because with the text messages and the timing and the drug deals and the multiple attempts, the poison, just the word poison, or as he was saying, illicit street drugs, I think that was more confusing as well. But, you know, I think that could have been kind of a cleaner, easier way to do it than starting out feeling like they were going to prove it was fentanyl. And then I don't really feel like they did prove it, but they didn't really have to. So it was just kind of creating this confusion. I think that was unnecessary. Obviously it didn't matter, but I like the poison theory and theme better than specifically fentanyl.
I agree. And I think there's a lot of room when Kouri was asking for the Michael Jackson stuff to just argue she was trying to find something lethal. And Kouri doesn't know. Kouri's used to ordering at Starbucks, which we saw from her, you know, her bank accounts. She's not used to asking for something illegal. And she doesn't want to be like, just give me something that can kill somebody. But she kind of did, as she's asking multiple people for the Michael Jackson stuff. The prosecution, I think, was in a little bit of a pickle with Hayden Jeffs, the witness who passed away on a motorcycle prior to trial. They brought in his partner, who hated being there, hated the prosecution, hated the IO, and who had those texts with the IO about, I'll bring a catch pole for your dog, which is just, what are you doing? This witness looks like she's been dragged off the street, forced to testify, and is pissed and only heard snippets of conversations. But from the pretrial motions, Jeffs had a very extensive conversation with Kouri about what she wanted, that also included the Michael Jackson stuff and conversations about fentanyl. And I think the prosecution was not able to take that out of their navigation of the case, even when it wasn't going to come in, because it came in a little bit, but not cleanly, because that witness had passed, and that happens. But it's hard.
It was a huge net negative for the prosecution. If you could go back and do it over, you don't even call her, because she brought almost nothing to the table. And then, I mean, I couldn't stop thinking about the dog catch pole and what they were saying to her. Like, if they're saying that to her, imagine what they said to Carmen and Robbie and all of that.
And imagine being the defense and not leaning into, look at how heavy-handed.
Yeah.
They're just trying to be cowboys out here. And they're going to catch a murderer no matter what with their catch pole. What are we doing? Throwing the cops under the bus is like the number one defense, or maybe number two after it wasn't my pants. What are we doing? I was surprised.
It's literally just like, you could have built your whole case around, they were not going to ever let it be somebody other than Kouri Richins. Yep. The family was going to point the finger at her. They were going to pay people to investigate her until they found something. It took a year before they made an arrest, hundreds of thousands of dollars before these people were even the state experts. And then you got cops out here giving out get out of jail free cards. Give me the details to convict Kouri for murder. Dog catch pulls if you don't show up here and talk to me before you testify, so I can tell you what to testify about. Laying the groundwork, giving them the blueprint. I mean, they had so many quotes that they could have used to just show that this was a railroad job, right? And they still don't have enough evidence, but Instead, it was just like,
it was too much of a swirl. I
yes.
agree. And I think it must have been frustrating for the prosecution. Of course, whenever you have a witness that passes in the course of getting ready for trial, it is not easy. And then the trial getting continued when they were going through all the change of venue motions. I don't know if that would have been different. I think the evidence would have been different had he still been alive, because he had those conversations with Kouri. And I, based on what we saw in pretrial motions, believe that those conversations did happen. I don't think she overheard a ton of it. And I think it was hard bringing her in. But I do think they wanted to tie back that Kouri didn't go to Carmen first. But I don't think it came out cleanly that she went to Jeff's first, got denied, then went to Carmen and was asking multiple people for the Michael Jackson stuff or the lethal stuff, because that witness was so incredibly hostile and they would have known that beforehand. But the defense, I don't think, capitalized on a lot of opportunities that they had. I don't think that's a lack of strategy. I just, the way they see the case and the way I see the case was different. And it's the same with the prosecution. I think they were stuck in knowing that fentanyl was in this conversation and couldn't pull it back out to say, Kouri didn't give a shit what she got. She just wanted it to be lethal, because anything and too much could be lethal, and she didn't care. And it might have been that the first time she actually got prescription medications, and that's why he had like an opioid pseudo allergic reaction. And the second time she got stuff that was laced, and that's why there was so much in his system, because she didn't know if it was going to be laced or not, and she wanted to make sure it was done because it didn't work the first time. And I think that's an easier way to say she just wanted something lethal. She didn't care what it was.
Yeah.
But
It's like, I don't care which gun, just get me a gun.
Right.
Listen, the only reason we know it was fentanyl is because it was in his system. Like, let's be honest. That's really the only reason we know it was fentanyl. I don't care what Carmen and Robbie say. Like, that's pretty clear to me. But it doesn't really matter if she was trying to poison him and she did successfully poison him and kill him, because that's what she's being convicted of.
Right. So she wanted to buy stuff. She bought a ton of stuff.
Right.
A ton of stuff ended up in him.
So what do you think about where are all the other pills? Where are the 150 other pills? Do you think she planted them in his truck, got rid of them before the fact? How did she go through that many pills? Like that, there's some really unanswerable things to me that I don't really get in this case. That's one of them.
I do not know cleanly how much ended up in the victim and how many pills that would have represented to dilute them down into the drinks, which I do think is how they were delivered into the victim system. I think some were probably flushed. I also wonder if that transaction after Eric passed went into an allergy bottle into his truck, and then she was pissed that it never got searched, because that was like a backup plan in hindsight. Oh, I should have. I don't know where the original group of pills went, but I think that second round of pills went into Eric. And then I don't know if stuff got flushed, if he saw stuff and she flushed it. We don't really know what happened between Valentine's Day and March 3rd, but I do wonder if the transaction afterwards ended up in the truck, and that's why she was so pissed about it, because they focused on the allergy bottle in the truck a lot. And it was in the walk the dog letter. It was elsewhere. I wonder if that's because she had put it there and knew that Eric wasn't around to refute that.
How did the cops not search the truck? And how did they not test the pill bottle? Like, I don't understand those.
Well, the truck was gone by the time they did the search warrant with the business partner, and then they never followed up on it. They were like, oh, the business partner took the work truck. But even if they had searched it, what's the argument if you're the defense attorney? The truck is taken possession by the business partner. They go search it 2 months later. What's your argument?
Yeah, I still would have rather seen it searched. I mean, that's the point is, it's just kind of like, it's just, there's so many things that they just didn't do in this case, I feel like, and that's why it took so long. Honestly. I mean, that's why it took so long.
It does seem that they do not have a lot of homicides in their jurisdiction, and it was not where their head was at. And I honestly think that Detective Woody, when she came in to investigate the death scene, even though the sisters were like, we think the wife has something to do with it, I wonder if Detective Woody was like, okay, yeah, this would have advertised. I understand. Go sit down. I don't think Woody took that and was like, oh, it must be Kouri. I think Woody took that and was like, I understand that you've just suffered a loss. It's more likely that he probably just passed. And when the tox results came back, I think everybody went, oh shit, he didn't have a heart attack. He didn't have an aneurysm. It didn't look like an accidental OD scene at all. And I think when they went, until the tox came back, I think everybody was operating under, I mean, he probably had a heart attack and aneurysm, and died. That's what it looks like. And so I think when the tox results came back, they all went, what do we do now? And that scrambling kind of continued. And I don't think if the PI hadn't been involved in the civil case, which Kouri brought on herself by suing the estate, I don't know how much of that would have gotten tied together, because the PI was dogged in looking after this
Yeah,
case.
that's one of the witnesses I want to talk about. What did you think about his demeanor, his involvement? How do you think it makes law enforcement feel that he basically came in and cracked the case? Because they were like, yeah, it was pretty slow until he came in, and then he added some fuel to the fire. And there's no doubt about it, he absolutely did. What did you think about him?
I loved him, but by the time he testified, I was so frustrated with the defense. And I want to see good lawyering every case we go into. When the defense in opening pointed out the expiration date on the pill bottle wrong, I was like, oh, I can't trust you. You came up with this whole opening statement with, they're going to try to show you a witch and we're going to show you a widow. And they're like, this expired on that date. I'm like, that's not the right, I can see that with my eyes.
The date it was actually prescribed, right?
It was, yeah, they were transposing the prescription date with the expiration date, or the use by date with and I was like, if you're misstating that to me in opening, I can't trust what you're going to represent the rest of this case. And that surprised me that it was so.
Maybe I'm too naive. I always feel like, are lawyers really going to be that dumb and say, like, this is my left hand when it's like very clearly your right hand? Like, mistake versus intentionally doing that. Because intentionally doing it, first off, they could have said it was expired or past the date. Even the other date wasn't it 2020 or something?
It made no sense to me. But I'm like, and she was looking at the thing, saying the thing was wrong. So even if that was a mistake, I still can't trust what you're saying is true.
It's true. You can be wrong multiple ways, even if it's unintentional. It's the same thing as like, you were in Hawaii when this happened, right? She was like, no.
Exactly. So if you're so confidently wrong,
Yes,
I don't know if it's malicious or if it's misstatement or if it's a combination, but it makes it hard for me to rely on what's represented. So by the time we get to Gabler and he's giving it back to the defense, I think in a different case, I would have probably viewed it differently. But by the time he's there and he's like, no, I don't agree with your insinuation, I was like, fair, go get him. I think that there's a risk, though, that jurors are like, who is this dude? And why is he snapping back at her? But I always say that you have to earn it. And we've watched so many cases when lawyers clap back at a witness, they've earned it. We saw it with Camille Vasquez. We've seen it with Alan Jackson and others. But if you don't earn it and you just come in too hot, you're going to lose the jury, I think. And so by the time he was getting feisty with her, I thought he had earned it. But that's my perception. But I was surprised at the vast difference in how Gabler was ready with every single fact after just having like a multi-level spinal fusion. And then O'Driscoll, who's like, I mean, I don't know. Somebody looked at it.
Not my job, man. Like, I was just the lead investigator. I don't know.
It was wild, but Gabler I thought was great. I didn't realize how much he had done before law enforcement came in. And I can understand why the defense was trying to distance themselves from him, but he's not meant to be neutral. He's the guy. Pardon?
You mean the state? You said the defense trying to distance.
The defense was trying to, push him into the case.
Oh, gotcha.
I might have transposed that in my brain, but the defense was really trying to push him more into the case to make him kind of the linchpin. But I think they could have, if they wanted to, go further with that. And I'm surprised, witness scheduling wise, I would have wanted him to be the last witness, I think, because he had such a good grasp of the case. But there are also things they needed to bring in with the IO. But he made a huge difference in this case. And I think that was a big win. Also, the defense kept trying to needle him like, oh, well, you weren't going in neutral. He's hired by the estate to investigate what happened through the estate. He doesn't have to be neutral, but that can ruffle jurors the wrong way. And that's something that I don't think happened here. But it was also kind of fun to see him taking shots at the cops. because he's a defense investigator. It seems like most of his career. He reminded me of you, Peter, when he stood up and he was like, I stand between my client and the state. That is my job. And I was like, that dude's a defense investigator through and through. Always has been.
Yeah. To me, it was like locked and loaded. This guy's might as well be a state witness. Like he's definitely going to help the state. Like to me, he's quote unquote biased to the state, like any expert witness would be. Like none of that bothers me. But again, could be different from jurors. I could have done without the 3-piece suit for an investigator. Like maybe come in a normal clothing. But here's what I say. I think that my feeling initially to him was like, oh, this guy's going to do whatever he can to help the state. Like clearly he's looking for something. He's going to find something. He's clearly smart, hardworking, did the work. But the best thing he did, which is how you know he's a pro and he's got experience, when you're wearing a GoPro everywhere you walk in the house with thousands of hours that the defense admitted in front of the jury that they watched all of the tapes on, and this is all they could come up with. To me, I was like, I don't really care if you think this guy's kind of like, eye rolly. Like I liked him overall because I thought he was really smart. I can put aside maybe like the vibes were like a little ick to me for this guy, but like I can put that aside and be like, he was smart, he was professional, he did his job. But when you're wearing a camera everywhere you go, you're not afraid of what you're doing. You're not hiding what you're doing. You're not giving get out of jail free cards and crap like that. Like to me, this guy was about as above board as you could be as a witness, as an investigator. To me, that's incredible when you go to his credibility. And then also the way that he reacted, some people didn't like. I liked the way he reacted to the, whatever, I'm going to leave my wife for you, talking to your best friend kind of conversation between guys. That was so stupid. They brought it up and he reacted like how stupid I felt like it was as well.
I thought he earned the right to stand on business with the defense because he knew his shit. He knew his case and he knew there was nothing they could clock him on. And the defense made, I think, a critical error by trying to flame him on taking a laptop out of the house. And he's sitting there going, that was my laptop that I brought into the house and took out of the house. And the defense really in that moment showed that they did not have a better command of the case than this witness did. And that's not a good position to be in if you're trying to go toe to toe with this witness who knows more than you do. I actually would have liked to have seen Ramos do the cross of the PI. Yeah. I think it would have been a better cross because the way that they tried to go after him, he's like, oh, I'll match energy. He didn't start out that way. But once that energy came at him, he's like, oh, this is what we're doing? Game on. I'm here all day long. And then when his neck started to hurt and he had the neck brace on and the defense attorney's trying to yell at him and he's in his neck brace after surgery, I'm like, ma'am, you have to take a step back and see how this is going to come across. Because even if he's clapping back at you, it's deserved at this point.
Yeah. It's I've had, pregnant witnesses that I've cross-examined. It's like, it's just got to be different. Like the optics don't look good if you do a certain kind of cross. I agree. I think Ramos would have been better because I also think whatever you want to say about Ramos, and it would have been, fiery, but he didn't really go down lines where he didn't have the goods on, like with the text. And this would have been inappropriate in my opinion and not proper candor with the court or done in good faith. But it did sound better when she was like, there were sects on that phone, right? And he was like, I'm not sure. I don't remember all the text messages. I would have just moved on because I thought there were. When she's asked that question, I was like, oh, so there are some. So Eric was getting frisky with some people. And then when she kept getting into the details, it just all fall apart. And it's just like credibility gone once again. They just lost credibility throughout the case instead of built it.
We've seen it in a couple cases, trying to make things appear as if they're not, like the text with his friend. I think any juror is sitting there when the PI is going, oh yeah, he was joking. We have an open marriage, buddy. So I'm having you come over tonight. When you try to make that serious and then double down on it in closing, you really burn your credibility because now at the beginning of the case with some of the witnesses, I was like, oh, was Eric texting somebody? Was he involved in something? And one of the partners was like, oh, there was a thing with somebody, but I don't really know. And it was kind of vague. But then as the defense tried to build it through Gabler, who knew the text messages, and it was him, joking around with his friends, I was like, oh, so none of this is true then. Because at the beginning, I was like, maybe that's true. And it happened towards the
emotional affair stuff or whatever.
Yeah. It happened towards the end of trial too, when the defense was trying to insinuate that maybe Eric was the one sending the memes of I'm so rich and idiots everywhere. They were trying to insinuate that in O'Driscoll's testimony. And then it came back round that that was not it at all. And there were some questions I don't think the defense had a good faith basis for. And it really rubs me the wrong way because the defense generally, for me, gets quite a lot of latitude, which depending on the case, I get criticized for. But I give the defense more latitude because that's the role that they play. The prosecution's role is very different. And the no good faith basis to ask the questions is one of those hard stops for me. And I was surprised by some of the questions trying to just attack Eric and try to insinuate that he was having an affair with his friend Bryce and what have you. It was really inappropriate, and it was a real big turnoff for me. And it kind of by the time we got through Gabler, I was like, give it to her. Yes, get her. Because I was so frustrated with the questioning. And I think Ramos would have done that better. His first cross-examination was one of the most ridiculous things I've seen. But he iterated.
I was like, get out of here, bro. Get out of here.
And with a cop that was just like, I filled out the death investigation. He's like, you did. You did. I was like,
you did that. Yes, sir, you did. It's like, that was great.
What was your favorite theater production in college, Ramos? I need to know because it was.
He was good too.
Yes. Way too theatrical. Ready to be on Broadway with Whitney Levitt from Secret Lives of Mormon Wives doing Chicago and gun the gun. But it got better.
Yes.
He corrected course quickly. I don't know.
With that cop, I thought he had good point. He made good points with that cop. Again, it was the delivery that was like, settle down. But yeah, but I thought I actually really enjoyed a lot of what he did. Yes, exactly. Okay, so they finished with O'Driscoll. I get what you're saying. I thought that, the PI was a better witness too, but he really wanted to finish with the walk the dog letter and the book and all that stuff. And that comes in through O'Driscoll. You already kind of mentioned how I didn't know what your feel was or what your vibe was on him, but overall, one of the worst lead investigators I've ever seen on the stand. Totally okay. And even Bloodworth on redirect was like, you didn't do this. You weren't responsible for this. Somebody else did this, right? Somebody else that it's like, so he didn't look at it. He wasn't sitting there during the whole trial listening to them testify. I thought the defense gave him latitude to where he could have really, kicked the door down, and he just didn't.
Yeah. It was rough. And then again, from him being sprawled out in the interviews, I don't think if the jury connected that was the same guy. And the defense didn't come back with the catch pole stuff and remind the jury that it was him, which is probably so he couldn't answer about it. But the kind of lackadaisical answering was surprising to me. It felt like he wasn't invested in this case or even maybe paying attention to it. And I don't really know what that was, but when you're the investigating officer, you need to know the case well. I don't care that Kostradimus is your expert for digital and that you have a forensic accountant. You need to know what they know. Aren't you writing warrants? Don't you have to write affidavits? What are you doing? It's like, oh, I don't know, somebody else did it. I'm like, what is this? And it might have been his first homicide case that he worked, but I would think then you err on the side of knowing your case too much. And it's not like it's a new case. This case has been going on since 2023.
And it's not like he didn't know this was going to be a big deal. And like people were going to be watching this case. It's not just like your everyday homicide. Right. I was embarrassed for him, especially comparing him and the PI. It's like you had to have this guy come in and do your job for you. And all you did was threaten witnesses to testify. Like to me, it was one of the worst performances or work done by a lead investigating officer that I've ever seen. And again, small office, whatever. But I mean, nobody should feel bad for the resources on the prosecution team when you have defense teams in every single trial that just don't have the same resources. I don't care how small your office was. And it was just, to me, it was a bunch of excuses. It didn't make it seem like there was a reason I did this or didn't do that because of this, which again, then it's, based on your experience and education, and you're making these decisions and it's strategic with how you're going to prosecute this case and investigate this case. But there was just none of that. And again, yes,
you have to know the case. That's it. The period, full stop. You have to know the case. And if somebody else did it, you have to know what they did and say, well, so-and-so did this, but they did this and this and this and this. And then if the judge cuts you off and says, well, you can't testify to what they did, at least you've said, I know what so-and-so did. They did these things. You have to be the umbrella. And he did not do that well. And I don't know if that was nerves because of how much was cut out in pretrial rulings, because there were times where he was almost buffering and it looked like he was trying to figure out if he could answer, because I think part of his answers would have gone to things from pretrial rulings, and the defense was not always careful in their questioning. But I worry that that's just lack of trial experience, being able to well navigate that answer might run afoul. Because there were times where I think at least once or twice Bloodworth was like, Your Honor, we need to approach before the witness could answer. Yeah. And then the defense tried to recraft their question. And there were times I was like, I think the prosecutor is actually trying to protect the record so that the defense doesn't inadvertently elicit from this witness something that shouldn't be coming in that can cause this entire case to implode. And I think that is also, for officers that don't testify a lot, that's a really hard thing to navigate, but you have to know the facts.
Yeah. It was pitiful in my opinion. So after the state rested, what?
It was not great.
Yeah. After the state rested, defense rests. Were you surprised at that? Did you expect them to call any witnesses? Did you think it was a good call, bad call by them? Obviously, in hindsight, they lost, so it wasn't a great call. But what did you think when that happened?
I think legally it was a good call. I was stunned, but I shouldn't have been. And then I was frustrated at myself for being so shocked. But I'd watched all the pretrial motions. And in every pretrial, Kathy Nestor was like, we need this much time for our defense. These are the witnesses we're calling. This is what our defense looks like. The defendant is going to testify. We need time for this. So she was laying that groundwork. And I don't know if strategy changed or if that was the chess game to get the prosecution running down, trying to cut off witnesses that they may call so that they could get into it. Because then in trial, you start to look back going, they were trying to do direct examinations of witnesses to save time. They were trying to expand the scope so that maybe they didn't have to call those witnesses. And the prosecution most of the time was trying to cut them off on that, which was a solid plan. It's like, no, call them in your case then. But Your Honor, it'll save time. And the prosecution's like, I see where this game's going. You call them in your own case. We're waiting. But I was surprised after how much fuss was made about the amount of time needed, that at the end of the day, we're calling no witnesses because they had experts. They had retained experts. But I do think it was a good call. I just don't think this was the defense team to maximize. The state didn't prove their case, and they'd already lost a bit of credibility and couldn't really bolster it back. But the defendant testifying, like, I would have loved to have seen it. I'm super curious. It was the absolute right call that she didn't. It would have just closed all of the doors. I don't think there's anything she could have said that would have helped. There's no reason for her to testify. There's things she can't explain away. And enough of her words came in that the defense could be like, the walk the dog letter's true. It's just true. There was enough for them to work with there. And I think her testifying would have opened up all of her interviews with O'Driscoll. There were 4 or 5 that were recorded. And she does not come across great in those. I've heard some of those in pretrial motions to suppress. So it wouldn't go well, I don't think. And
what's she going to say? Like, she's already told her story of what happened multiple times. You know, we got 911, we've got body cam, we've got the journals. Like, what is she going to say? What's she going to say to help her case?
Nothing. There's nothing she could have said to help, because you can't try to excuse it. What's she going to say? Oh, I do think Eric and Bryce were having an affair. Nobody believes that. No one's taking you seriously. So I think it was a good call. I did not like the theatrics of it, of the, oh yeah, Your Honor, we're ready. Okay, what are we doing? Well,
we have a bunch of options.
We need to talk. We still have the theatrics of it, really, especially when it's just the court and counsel. The theatrics of it was so unnecessary, and it was kind of par for the course at that point. But the theatrics bothered me.
It did feel like sometimes they were hyper aware of the cameras and what was going on in the courtroom.
The lack of candor to the court at times I found very frustrating. Because however you want to try your case in front of the jury is fine, but that duty of candor to the court is still owed. And some of the gamesmanship, I get it with the state. Tell the state you've got 15 witnesses and make them go track it all down. Fine. Do whatever you need to do. Give yourself the room to try to give yourself as many options as you can when the state rests. But when you get down to, oh, wait, we need to talk about it more. You just had an hour and a half break in the day. And now you're going to sit here and whisper in each other's ear because you haven't decided what you're doing. Ramos was sitting at the end of the table looking like he was about to puke.
He did not like it.
No, it was, to be a fly on the wall. It was a very interesting moment. What did you think? Because you've been on that side of the table making the decision, and it's common. I think people were like, what's happening? I'm like, well, this is what normally happens. The defense does a lot of cross-examinations and then they rest. That's what normally happens.
It's like more than 50% of the time we probably put on little to no case at all. But Ramos's feel of being stuck on that team had to be brutal. Like, I've talked to some lawyers that work for certain firms, and you go try cases and it's just kind of embarrassing at times to be part of certain teams, especially when you're the younger or lower level lawyer or whatever it may be. I think that it's hard as you on the defense side. There's so many things going on and so many things to consider. And as a prosecutor, when I prosecuted cases and now as a civil attorney, as a plaintiff side, like, you're going to put forward your case, you're going to hit the elements and explain, and you have the strategy of how you're going to prove it. And then, of course, responding to the defensive side. But on the defense side, yes, you're attacking. Yes, you're poking holes. Yes, you're fighting. But there's always like your best argument or your best theory in the case is they haven't proven it. And sometimes the only response to that is to put on no evidence. So you always have that as like every trial, because some trials are self-defense, some trials are this, some trials are that. But every trial you're thinking about the not proven, right? The reasonable doubt side of not guilty. So that's legitimate. And a lot of times you have to have that discussion early on so that your client can understand it's not that we're not doing anything. It's not that we're not working for you. Yes, we've paid experts or we've deposed witnesses, at least here in Florida, and we have those available, but that doesn't mean we're going to call them. And here's why. And sometimes that can be very difficult because most clients want to tell their side of the story, want us to prove what they're saying is true. They swear the state is lying, and all these witnesses will come and testify and be so great for them. So those conversations have to happen early on. It's not a split decision, but there are a lot of conversations going on, and good lawyers, in my opinion, those conversations are continuous. It's not like, okay, our case in chief is tomorrow, let's start having this conversation. It's from like day one. And each set of witnesses that come up, okay, they did this, we can respond with this, or it was actually really good for us because they didn't get into X, Y, and Z. And if we call this witness, they may be able to. So that strategy is kind of going on throughout the entirety of trial. And it is a big decision. It's not an easy decision. So sometimes it does come down to the last second, going back and forth, getting your client's confirmation. But my dad pointed out that there wasn't even a big conversation between them and Kouri when they told the judge. It was like, it was done. Like at that point, it was done.
It was just them whispering at each other. And it was one of those moments where I was like, not this again. There were definitely moments I was frustrated, and I, again, saw other avenues for them to focus their case instead of throwing it all up against the wall. I thought it was funny that Bloodworth put up the poop slide with
some memorable slides.
The shit against the wall. But when we got to closing, I think that's probably where you're going next. So I'll hold my question because...
No, go for it. Let's get into closing.
I was curious about your thoughts on closing because I think our thoughts probably differ wildly on closing just from some of the comments I've seen of like, well,
Bloodworth,
I love it. I know we don't always get to talk. And then chat's like, well, Peter said this and Emily said that. And I'm like, I that's part of what you heard me say, but there's more to it. But
yeah, always that happens. And, it's always a grain of salt, but it's always fun. So for Bloodworth's closing, I thought there were some A+ amazing nuggets, things I hadn't thought of. One of my favorites was every time Kouri told the story, she started at 9 p.m. That's where the story started with Kouri when they drank the Moscow Mules. Not I woke up in the morning and went to work that day. Not I woke up and touched Eric. I came in from Ashton's bedroom and touched Eric's cold body, which would have been two very natural spaces or places to start the story. Instead, she always started at 9 p.m. To me, that was A+. We already talked about some of the connections that he made, playing the 911 call with the 6 minutes. A big thing for me was her phone starting to move at whatever time for 15 minutes before she actually calls 911. Those are all things to me that, what are you doing? I just said that I would probably have said it. I thought it was too long, my personal opinion. And I thought it was a little bit convoluted, like not convoluted. That's not the right word, but it was like, he would talk about this and then he would start talking about this. And then he would start talking about this, all important and good points. But I would have liked, here's how we know she did it. What she did before the crime was committed, what she did to commit the crime, and what she did after the crime was committed, and putting them in those three buckets, I think would have really made her look bad because you could really go into the motive, the money, the insurance, the setup, buying the drugs, the attempted murder. You do all that before. Then you get into the specific dates that she bought the drugs, asking for something stronger. The Michael Jackson drug. Her night started at 9 p.m., committing the actual crime. You get the 911 call, the movement that she made, the 6 minutes before doing CPR, and how she acted, when everybody came to her house. And then you get the afterwards. You get the celebration of life, the partying. She had the affair before and after. She had the plan for Eric's business. She had the plan for her money. She spent the money in 3 months. She writes the children's book. She gets arrested. She writes the walk the dog letter. She's trying to make up these lies. She deletes all of herself to try to cover it all up, just like a guilty person would. I thought that, just like in my head, obviously he knows the case better than me and knows so much more about it than I do. I hate always even saying, people are like, what would you do different? And it's like, it's impossible for us to be in their shoes.
It's easy for us to sit here and be like, I don't know. I might see it this way. I might see it this way, because you don't have all the trial stresses. I also think that the defense team, to me, seemed like they were sick and getting sicker the entire trial. I have been in trial sick as shit. It is the worst. And your brain does not work right when you are like Dayquil'd to try to like get to court. And that is not ideal. But you really don't get a 3-day recess because counsel's sick. You get to court, and that's unfortunate. But I do think
pre-COVID days. Like I remember I would show up sweating on my drive to the federal courthouse in Tampa. It was like a 6-week trial. One of the weeks I was deathly ill. I was telling my dad, I was like, dude, like I can barely see straight. I'm sweating through my suit right now. And it's brutal, but you got to do it.
Yeah, it's not the healthiest aspect of being a lawyer when you're riding through. But judges, even if you said, I am too sick to continue, most judges are like, I don't care. Get to court, figure it out. And
breaks, we'll let you take breaks.
Yeah, we've got a jury. We're not burning 2 days with a jury. We're going to lose this jury and have to mistry the case. We're not doing that. But I do think the defense team was also under the weather, and it seemed like it was progressively getting worse to closing when both of them were losing their voice. I loved Bloodworth's closing. I see exactly where you're going with how to order the time. He went in order of the indictment. It sounds like you would have flipped it and started at count 5 with the forgery fraud and like build the timeline in real time, pre-murder, murder, post-murder.
Right.
And what I appreciated about his presentation is that every slide was oriented to which count it was going to, like he did in opening, which I really appreciated. And he went through the elements. Did you look at the elements in depth, Peter, when he was closing?
No.
The elements for murder in Utah are just like, you killed someone. The elements are so, the jury instruction is so short. It is so scant. It was wild. I was like, those are the elements for aggravated murder. It's just it that she willfully caused the death. Okay. It was wild to me, but I loved how he brought every element up, labeled every single slide so the jury was oriented with, and I appreciated the time he took to walk through because of the way the presentation of evidence came in. I think there was a lot in that closing that the jury was piecing together because it wasn't always as easy to grab something out of it and go, oh, that goes to the forgery. Oh,
Sure.
that person goes to this. I really liked it. I liked the methodical way that he kind of marched through the counts, and there were great moments. I also appreciated his pacing was consistent throughout. And I think there were pointed moments. At one point, he called her a bad writer. He had pointed moments, but he wasn't heavy-handed with it, which some prosecutors get a little too fire and brimstone, and it can feel too much like the weight of the state falling down on somebody's head. And I think that turns off juries. I think he was very much even-keeled, and even with some zings. What did you think when the defense made their motion for mistrial about the Black Widow comment?
So the Black Widow and the narcissism, I was like, are those just not arguments? I don't understand how that's just not an argument to make about, like, everybody knows what those things are. It's not like you were saying you have to have somebody come and testify that she is diagnosed with narcissism, or that, this is the definition of a Black Widow. That's like saying he's Superman. Objection, Your Honor. Nobody testified that he was Superman. Right. It's like that just, to me, so much of what they did, and the same thing with their closing, anything good that they did, which I agreed with their objection about the facial expressions. I don't think it was appropriate for him to comment on that. they would lose it in just doing too much or trying to do too much or saying things that just weren't true or weren't legally appropriate. And that was a perfect microcosm of that. Is like, you had one good point, 2 out of 3 were bad. So then we're all like, what are you doing here? Like, what are you doing? It's closing arguments. He's arguing.
I was very surprised during the case after their opening with the witch widow, because I think he was pulling things from their opening with that. And then they knew, unless they forgot, they knew that Chelsea Barney, the bestie, was referring to Black widows. Who chooses to use that word in opening knowing that that's buried in there? You try to bury that shit as far away as you can and never let the jury think of the Black widow. But when that comment came up from Chelsea Barney, I was like, oh, the defense knew that was in here and still picked the witch widow analogy for opening. That's a weird
black, right? I mean, it was like a picture of a witch wearing black.
Yeah, it was I don't know whose artwork it is, but it's a pretty famous, you can see things two ways.
Right, exactly.
But the tech presentation of the state, I thought was easy to follow. They made a lot of connections I hadn't made. And you could see where Bloodworth put things in his pocket for later in trial, because with that very first witness, the whole exhibit came in with the narrative that Kouri wrote, but they never showed it. They never read it. They never went through it. It was just like, pocket. That's going in the pocket. We'll pull that out at closing. And I think they pulled that out to great impact, because it was one of those moments where I was like, I'm mad I didn't see that. I'm mad I didn't connect those dots, because it was such a good connection that she didn't start with, I walked into the bedroom. And I was like, damn, that gets both fingers. I thought it was great.
And that's why they thought it was the Moscow Mule. It's like, and that's how you see, it's like, once you live with a case for years, you think we, or you in this case specifically, because you did so much pre-trial on it, like you already know too much and have kind of what you think that imagine for the people listening, like living with the case and the investigators and talking about it every day with O'Driscoll, actually probably not O'Driscoll, calling the PI or whatever and talking about this case. Like, you have what you think happened, and it's hard to make your trial strategy more vague when you think you know exactly that she put the fentanyl in the Moscow Mule in the kitchen, and Eric drank it at 9 o'clock or whatever.
Kitchen with the copper mug. Exactly. Yeah, absolutely. And the thing that was hard for me when we got to closing is how much the defense had promised in opening. And I think it's hard for jurors. Yes, the defense does not have to prove anything, but they made promises. And if you make promises and you're not going to follow through on them, it creates tension for the jury that you've made promises. And then she was like, yeah, strategies change. I'm like, but the facts don't change. You knew what the facts were before you did your opening. And strategies change. Yeah, there's stuff we didn't show you. We said in opening. Oh, well. I'm like,
I love that the state commented on it, because they did it appropriately without burden shifting. I was annoyed that the state and Walsh didn't do that, because it's like, that's totally appropriate. When they say certain things are going to happen and they just don't, like, that's bad lawyering to me. I get it. Trust me. I get how defense attorneys are. I get the different levels and what their job is and what the prosecutor is, right? Most of the time I'm probably on the far other side, but I just don't like stuff like that. That's the type of stuff that bothers me, annoys me when I'm a lawyer on the other side, where I just can't trust what you're saying or believe what you're saying. Make your arguments. Pull one record out of 1,000 pages. That's fine. It's one record. It's an actual record, and it says that, and you make that argument. That doesn't bother me. But when you pull out a record and you say it says something that it doesn't say, that frustrates me, annoys me. And now I am going to nitpick you to death for anything you try to do, and make sure the court knows I think you're misstating things intentionally. So I'm glad that the state commented on that. Usually I would be sensitive to burden shifting, but he didn't, and it was appropriate, and that's what happened.
Bloodworth was really careful with the way he did things, which shows the experience that he was able to navigate commenting on it without burden shifting. And I don't know if all prosecutors are as confident doing that. And I think we saw that in Walsh too, that I'm just not touching it.
Yeah.
I'm not touching it. I think we're going to get a conviction in this case. I'm not going to touch it. I don't want to create any problems. And I think Bloodworth navigated that well, with a few little moments of zinging at Kouri. But from a prosecutor perspective, I get it. I can only imagine how many hours of jail calls he's listened to Kouri Richins. Like, he knows Kouri Richins probably better than her attorneys know Kouri Richins, and better than Kouri knows Kouri Richins at this point, because he's listened. And when in pretrial litigation there was fighting about the jail calls and stuff, she was on the phone for hours a day talking about this case, talking about the coverage of the case, talking about her lawyers. I'm sure talking about the prosecutors, talking about whether she was going to smuggle crushed white strips into the jail, like she said in the walk the dog letter. But she was talking so much. So they have listened to probably hundreds of hours of Kouri talking about them, this case, what idiots they are, the witnesses, her sister-in-laws. And so by the time you get to closing and he's like, she's not even a good writer, I'm like, oh, she's going to be so pissed. And then there's a second prosecution. So they still get her jail calls. So if she's pissed after closing and getting on the phone, they still get the jail calls because she still has another prosecution.
Yeah. Yeah. No, I thought that, I mean, I think that he handled it appropriately. I do think that some prosecutors, it all depends on how you're taught, I think, because everybody comes in as a young prosecutor. You were probably taught in LA a lot different than I was in Clearwater, Florida. Just depending on who the supervisors are, the cases that come through. There are some that are going to handle it like Bloodworth appropriately. There are some that are going to handle it like Walsh, where they're too scared, they don't want to touch it. Then there are some that are going to inappropriately burden shift and be like, appeal be damned, good luck. I'm going to convict you and then good luck on appeal. And that's the worst kind, frankly. So yeah, I think he handled it appropriately. I do. What did you think about the only time I can really remember him doing something that I thought was risky on appeal, besides the argument about the facial expressions, was that whole, when Cody was on the stand, the whole hearsay, opening the door to more hearsay about somebody told him Eric took pills in high school, and the judge ruled in a way that I was like, well, why are you doing this? And Bloodworth was like, and the judge was like, hey, in a moment of humility and an abundance of caution, Mr. Bloodworth, do you want me to do this? He's like, yeah, judge, we'll go with your order. I thought that Bloodworth was kind of avoiding that most of the trial, but went with it there. What did you think of that whole discussion?
I think that there was room for the prosecution to push. I think there were times when the judge was being overly cautious and the prosecution acquiesced. But I also think that Bloodworth, sitting there looking at the jury, had to look at the jury and be like, this is not the battle to fight to win the war. And I'm going to kind of acquiesce to the court on that in an abundance of caution. I think he could have pushed back on the court, but I also think that shows a level of experience, because Bloodworth was pretty nimble in responding to things in real time, but also it was a lean prosecution. They pulled in exactly what they needed and nothing more, which for some, they're going to be like, it was too lean, which I understand, but you can tell a lot of the times when a jury's following along with you.
Oh yeah.
Sometimes not, but in 3 weeks of trial, you can tell if the jury's dialed in. And apparently they were taking quite a lot of notes from the interviews we've seen and from those in court that have talked about how often the jury was taking notes. So if you know they're following the details, you can let some of those little rulings go. And if the judge gets it wrong and you get a conviction, it can cause a lot of problems down the road. But if the error is damaging to the state, there's nothing the state can do about it, truly. They're not going to take an interlocutory appeal. They can't appeal it if she's acquitted. It's not going to create an appellate issue if they win. So you kind of take the hit on that. And I think that's a solid strategic call. And I think Judge Mrazek did a very good job of trying to stay within the bounds of the law, even if sometimes I was like, oh, come on. You don't need to be that cautious. But I don't think this case is going to have some of the appellate issues that we've seen in like a Murdaugh. The facial expressions didn't bother me nearly as much, but also you could see at times Kouri was expressive with some of the witnesses. And I wonder,
100%, you just don't say it. That 100%, her facial expressions, I was like, especially when she's like, what? Like they're lying or that didn't happen or yeah. It was just like, no, just stop. Because she was pretty reserved throughout a lot of the sad witnesses, and it's just not a good look, obviously, which jurors notice. But all right, the last thing,
seeing Kouri on camera, and it's a different angle than some of the jurors are going to get from where they're sitting in the jury box. So that also might have seemed bigger watching it because the cameras are facing her versus from the side. But
very true. Very true. So what did you think of the juror interview? Any surprises? Pretty much what you thought?
We didn't talk about the defense closing. I want to know what you thought of the artwork and the get out of jail free card and the tech presentation from the defense.
I thought it was so much worse than the prosecutors as far as the tech presentation. With anything else, right? Like I feel like I am on repeat with the defense. I think they had some good points. Like I really do. I think the closing had some good points. I thought a lot of it was lost in the delivery. I felt like she went up sometimes when it was weird to go up, and then she'd come down. She's pretty much locked behind the podium, felt like she was reading it pretty much, didn't react to a lot of what the state said. She kind of had what she was going to do pre-planned.
Yeah.
And I think a lot of it fell flat. I would have just not even responded to them saying that we didn't, give you the promises that we said in the opening. And instead she made that comment, which was like a throwaway comment, which basically would make me think as a jury, like, just side eye that, like, what are you talking? Like, that's it. It's like, so we didn't do what we said we were going to do, but strategy changes. And it's like, and I think some jurors who think negatively of lawyers, some jurors are out there that do think negatively of lawyers, if people can believe that. When you hear the word strategy change, you're like, so are you trying to trick us?
Yeah.
Like, what do you mean strategy? Are you lawyering me right now? What are you trying to twist when you said strategies change? So that was just, a tough watch. But again, I thought they had some really good points. I thought, the Carmen credibility was a really good argument for them. I thought the summation and the ending of Driscoll, like, you can't prove this, you can't prove this, you didn't do this, you didn't test this. That would have been a better, rapid fire kind of thing to go through in closing as well. Cause I thought that hit really well with O'Driscoll. And I would have just been like, this is the lead investigator. And the ME, it's like, we don't have answers in this case. It sucks and it's sad, but we don't have answers. O'Driscoll doesn't have answers. The ME doesn't have answers. Nobody has answers in this case. And to come and ask you that this case was proved beyond a reasonable doubt, really? It wasn't. It's something like that I think would have been better.
They spent less time on reasonable doubt than I thought they would.
Mm-hmm.
When they got into the Constitution so early, I was like, uh-oh. If we're arguing about the Constitution this early, there's not much going to be else in this closing. But I was surprised that they didn't spend as much time on reasonable doubt. I think they said the word Constitution in closing more than reasonable doubt. And, that it's terrifying that someone can just hire a PI. I thought that was good, but it got lost in everything else. And it didn't ever tie back to doubt. I just felt like I was getting yelled at for an hour. And so instead of saying, how can you trust this? How can you rely on this? But the very beginning, when she started talking about her own experience being a young widow, I was like, what are you doing? I hate all of this. It's inappropriate. I probably would have objected, but I would have been annoyed by these defense attorneys, and I probably would have been objecting too much because I was annoyed. So I was really surprised that she was trying to gain sympathy and say, I learned in this trial that I was grieving wrong. I'm like, what are you doing? What are you doing? I was
just a misread too. Like, it was a misread of this jury pretty badly. Yeah. I mean, and again, I thought they had some things to work with. You had to go with a pretty, thread the needle approach, and they just didn't. Instead, it was like the walk the dog letter could be true. It's like, okay. I mean, I guess
pills from Carmen, one or the other, just you guys pick.
Yeah.
Your choice. Dealer's choice.
It was a tough look. It was not great, but I think she believed it. I'll give her that. I feel like she believed it by the end of her closing argument. But I don't think the jury did. Obviously.
The raise your hand for Kouri was too much. It was too much. It was too much. And
I also hate the go back there and make the argument you think I would have made. It's like, that makes me think you didn't do your job. Like, if I got to make the argument you would have made, like the judge had to do a couple times, that's not like endearing, and that's not like building credibility.
Yeah. And it kind of segues into the juror interview.
Yes.
Because it sounds like the jury was looking for doubt first. And it sounded to me from the snippets we saw that she felt the weight of, we didn't want this to be true. And it was hard for us to reach that conclusion, but everything pointed to guilt for us. And so the defense had a jury that was at least empathetic to them and could have done more with it, I think, had they been a bit more focused and precise.
Right.
But at the end of the day, I think most juries, no matter what the defense did, are going to look at this case and be like, nah, she's guilty. There's too much there. And her consciousness of guilt is off the charts.
It's the perfect story for a guilty verdict, right? Sometimes you have a really good story. Sometimes you have really good evidence. To me, this was really good story. A lot of circumstantial evidence of like, why else would she do this unless she committed the crime? And it just kind of fit together where they were going to hate her. Children's book, her own things that she wrote down, and the things that she did prior, obviously, to her friend and robbing Peter to pay Paul. Basically, it was going to be a really tough uphill battle for any defense team. to take this case. I don't think it would have made a difference if they would have put on a case or if she would have testified. I think this is how it was going to go, frankly.
I do too. And so I appreciated seeing a juror that took their job seriously,
Yes.
weighed the evidence, listened to everyone, and felt that the only door that they had was guilt. Even if people disagree, that's what you want a jury to do. And it seemed that they took the weight of that seriously, even though it was a very fast verdict.
Yes, it was very fast. They all wanted her to be innocent. They all were like, but she's just not. And they all were confident and nobody really wavered. Nobody thought maybe there's reasonable doubt here. And so, I mean, that's what you want from a jury, and you want to feel confident at the end they got the right verdict. They feel confident they did. From my perspective, I mean, I thought the interview didn't give me any red flags like something bad happened. And the fact that she said they were all like floored when they heard about the book, that's a good sign that they didn't already know about the case walking into it, which I find hard to believe that they didn't even know about the book, but that's a good thing.
I always am surprised by, we're in this world so much. So I know that my algorithm is so keyed to this, but even during Depp Heard, when I would talk to Brian about it, he was like, I see nothing about this case. He's just in his own world, doing his own work, and does not care. It's not something he's reading articles about, doesn't come up on his feed. He's just like, I'm just not tuned into it. And I think they sent out, do you know how many juror forms they sent out, Peter? No. 1,700.
And that's the whole change of venue argument. It's like with that many jurors, if you're the defense, you're going to get a jury. Like you're always going to get a jury. That's why you've got to do everything to protect the appeal for that with the objections and asking for more strikes and whatever, because 1,700, it could be
they sent out so many questionnaires, and they got back hundreds and hundreds and hundreds of questionnaires back. And Judge Emmett said early on in the case, if we want to exclude everyone that's heard of this case, you can make that argument to me. He seemed pretty amenable to say, oh, I might have seen a news article on it. He seemed amenable to say you can go, which I think is maybe over.
Yeah, but with 1,700 jurors, he can do that.
Not enough. So he was willing to kind of work with the defense on, if there's even a whiff people knew about this case, get rid of them. And the media coverage on this was not as much as in other high profile cases. It was more local. And I think the distance in time, you find jurors who are like, oh, wait, what? There might have been a thing about that. But it was interesting to me that the book was more heavy or weighty to them than the Walk the Dog letter.
It seemed like.
I was surprised, because the Walk the Dog letter for me, I was like, oh, girl, what are you doing? But the book really, I think, went with the financial motive that Kouri will do anything. The book goes more with the besties home. The Walk the Dog letter is like, yeah, of course she's going to.
Well, especially if you think she's guilty, right? If you don't think she's guilty, the book, you can look at it a bunch of different ways. If you think she's guilty, it's despicable. It's diabolical. It's like, who does that? Put this person in prison forever if they're willing to do this. That's the vibe.
Yeah. And I'm interested to see what they do at sentencing on the victim's birthday. When I rewatched the bail hearing, what I had forgotten was that Kouri, right after the death of Eric Richins, or the murder of Eric Richins, hosted a charity golf tournament in his name on his birthday, on his 40th birthday on May 13th, and told the victim's family, all of the extended family, that they could not come. So when I went back and looked at the bond hearing, and she was talking about how Kouri had distanced herself and the kids from all of Eric's side of the family, and was kind of leveraging the kids the way you'd hear in like a divorce case, leveraging the kids to get what she wanted from the Eric's side of the family, is how Eric's sister was telling it. But that this golf tournament happened, the entire family was excluded. Kouri was setting up accounts and saying, in lieu of cards, send money to this new account, to then turn around and have the sentencing be on his birthday 4 years later. I was like, that's wild. And the court was just looking at dates going, I have these dates, because the court was completely booked in April after being in a long cause trial from February to the end of March. So it's a wild kind of karmic wink, I think, in this case, that is rare that it happens. But when it does, you're like, oh, that's interesting. And the judge actually has some options on sentencing. And I'm really unclear what the judge might do, because he can go LWOP or he can go 25 to life. And I'm not sure.
I'd be shocked if he doesn't go life without parole. I would be shocked. That's the vibe I'm getting from him, I'll just say.
Which is interesting, because that's so true with judges who are like, I am going to err in the defense favor every single ruling to protect this case. But once we are done and we move to sentencing, we are done and we move to sentencing. And I think the lack of remorse is going to be a big one here. I think leveraging the kids is going to be a big one here. And I think judges can distinguish between your right to a defense and lack of remorse. I think there's more nuance for the court with that. And
we'll see what her statement is if she makes a statement at sentencing. And I don't know that he made every, ruling. I don't know if I see it quite exactly the same as you. I get what you're saying. I definitely agree with you that he was incredibly careful.
Yeah, fair enough.
With every ruling that he made, and tried to be as fair as he possibly could to her. But yeah, I'm interested to see if she makes a comment with, more cases coming, obviously an appeal, things like that. But I don't see any remorse. I mean, to think about how straight-faced she was throughout so much of the testimony in this trial was a tough watch.
And she was mad at times, for sure. And the juxtaposition with Josh Grossman, and how torn up about this he seemed, and how torn.
Grown-ass man, just broken up, right?
What's so funny, Peter, is I said that in stream that he was gutted.
Oh, really?
I'm like, this is a grown-ass man who's absolutely gutted on this. And I was like,
that's hilarious.
I'm like,
they for sure are watching stuff. Like, there was no doubt that they were for sure watching stuff. All the lawyers and people involved, in my opinion.
100%. Well, did you watch any of the suppression hearings?
No.
When they were
doing, think so. I watched like one or two hearings. I can't even remember.
When they were doing the suppression hearing about the walk the dog letter, Bloodworth stood in court and said, do you know docket item 214? Every law nerd on the internet calls it the walk the dog letter. I was like, did you just
that's hilarious.
Are you talking to us right now? And so there were moments in trial. At one point he said, to their tech guy, Scott, can you swoop? And I was like, you're using my words. And then the chat was like,
just locked in.
Yes. The chat was like, we need embiggen the next day. Next day. He was like, Scott, can you embiggen that? I was like,
and he's just dropping little hints, hints.
It was,
well, hey, it worked for this one, right? Maybe more people should.
I was surprised by some of those moments, but also they should look at what your chat is saying and what my chat is saying. I don't think the lawyers,
a huge focus group,
but somebody on their team should be taking the pulse of how the different lawyers see it, because it's such a good way to see your blind spots of who is seeing the evidence coming in differently, who knows more about the case, who doesn't, who and where people are seeing it. I don't think it should sway strategy necessarily, because then that gets to be a mess, but at least a temperature check on questions that your jury might be asking too as you go through it, I think is valuable. And we've seen that in case over case, that people have said that watching that is informative and helpful.
Yeah, absolutely. No, and I've had some people reach out saying that they watch or somebody's watching or whatever. And I think that it's a huge focus group, right? People do it before trial. Now you can do it literally during trial, with lots of people watching with lots of different backgrounds and lots of different opinions. But anything else that we haven't hit? Were you gonna say something else?
No, I was just going to say, I loved that we saw the prosecution use the photos of the witnesses on the stand from the court feed in their presentation to close. I thought it was such an effective use of reminding the jury who every witness was by photo. I wish I had that in my cases, to be able, instead of just saying the name, being able to show
or even having like their CV type of picture up there. Yes. They don't look the same.
Being able to show them on the stand. And it was clear that it was very mindful, because the pause faces that they chose were kind of with those witnesses as well. But I thought it was a well done prosecution. I liked how tech tuned in it was. I liked how much they used demonstratives and how effectively they used them, because I think you have to. And it was so easy to follow along. You can get lost in demonstratives, but when they're used well, it's really clear how helpful it is. So I thought it was I thought it was one of the
saw a
cleaner
trial
topics.
where there was too many demonstrative aids. I can't remember what it was. There was
Yeah.
one where I just felt like it was too many. It was like every word he was flipping to another
Stop it.
slide. But yeah, I think it was well done. I think the motive, means, and opportunity were the biggest points in this, and that's what he focused on. And I think that was what won the day at the end of the day. Well, I appreciate you coming on. As always, I value your opinion. So I love talking to you about these cases, whether we agree or disagree. Sometimes it's
Yeah,
more.
I think we have to explain that as lawyers, it's never personal. I'm sure you do this too, but every case I tried, I sat down with my coworkers and I'm like, please tell me where I'm wrong.
Yeah.
What am I not seeing? What am I missing? What are the other sides of that? Throw things back. So I get better by having those conversations. And I think in normal conversation, people do not like engaging that way because maybe it feels combative or uncomfortable, but that's something that I enjoy so much. It's like, oh, you see it differently. Tell me about how you see it.
It's helpful.
Differently. Yeah. Really helpful. And it helps you expand the way you think about something. So it's like, oh, somebody doesn't see it that way. Oh, tell me. Cause I am always open to like, oh, maybe I'm missing something, or maybe I caught that differently, or maybe I interpreted that differently. And you have to, as a lawyer, be open to at least 12 people's interpretation of what you're saying. And you have to try to keep that in your mind because jurors are never going to see it exactly the way you do.
Exactly.
And you want to know how other people see it. So no, I think
if it's about ego and blowing up and everybody saying you're right, that doesn't help you. Like, that's not helpful to me. I don't need that. I don't need the words of affirmation. I need the help, the blind spots. What are they going to argue? That's how I need to look at it. And so, I mean, that anybody that wants it the other way, to me, I think is doing a disservice to themselves, especially as a lawyer.
Lawyers focus on trying to be right. I mean, when you go into your case, you want to prove your case. That's not necessarily being right. That's proving your case to the jury. And lawyers really some do a good job of playing to their audience and trying to make sure that they're presenting their case in a way that works for their jury. The thing that I found different about doing commentary is I've stopped doing that because I don't feel I want to just see it how I see it. And I don't have to present it to a jury. I just get to be like, hey, come jump into my brain, see how I see a case. Let's have a conversation about it. And let's talk about the law around it and see where we're at. It's not about being right because it's just opinion.
Yeah. No, I think that's very interesting. And I think that's what people like. So if you want a colorful explanation, if you want to jump into the brain, right, you'd probably have a warning before people want to jump into the brain, but you can check Emily out. We'll link all of her stuff as always. I know most of you already know who she is, but thank you so much for coming on. I really appreciate it. And I hope we get to do it again soon.
I hope so too. Always a pleasure, Peter. And all of you in the LYK chat, you need to go like the video because I'm sure that I've pulled Peter into overtime. You're welcome. You're always going to get a supersized episode when Emily and Peter are chatting. Emily talks a lot, and that's just the way it is. We're very ADHD. We're very chatty. And I love the way that you're able to synthesize things for trial. I love getting to sit here and watch it play out day over day. Every time I've tried to synthesize it, Peter, I have failed miserably. I'm like, I don't know how he does this. Like I
have to go to the bathroom right now. I don't know how you go for 8 hours straight. I'm like, how does she do it? I don't understand. I've got to eat 15 times a day and go to the bathroom and run over here. And run. I couldn't do it. I'm glad it's such a cool place. Like the internet can be a really crappy place, but it is really cool that people can get the entire trial with commentary, learn so much. They can get it in recaps. There are people that do it even shorter, right? In 5 or 10 minutes or whatever. And obviously the depth is different depending on how much you can go into it, but it's a really cool thing to be able to have people that you can collaborate with and vibe with and talk to. And everybody's not going to get along with everybody, right? That's just kind of how it is. But it is really cool when you find people that you can hang out with, talk to about it, see things differently, bring different perspectives. I personally love it.
I do too. Thank you for having me. It's great to see you. It's great to see chat, and I cannot wait to talk about the next one. What are you covering next?
So is Fitzsimmons or whatever, is that going to be a thing now that it's a bench trial, I guess? Do you know about that? It's like a Massachusetts case. I don't know anything about it. That one people were asking about. And then Courtney Clenny, I think, is April down here in Florida, the OnlyFans model, right. Self-defense, accused of murdering her boyfriend. Those are the two on my radar.
That's going to be very interesting.
I know some of the lawyers involved in that one, so it'll be interesting too.
That'll be fun. Fun is the wrong word, but it's always interesting to see people
yes,
watch how they navigate a trial when you get to be kind of a fly on the wall. No, over here, I am navigating a senior in high school. April and May are going to be incredibly
I'm
busy.
sure.
So
Yeah.
it's going to be catching up on cases. And then I'm keeping an eye on the Keefe D trial out of Vegas about Tupac. I'm very curious when that's going to go to trial. And then I might catch up on things after they've been in trial because scheduling is going to get real dicey. But that's why we have jobs that we can pick to work around
There
life
you go.
and family. Thank you, Peter.
Yeah, some control over it. I appreciate you so much. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.